Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to another in our series of podcasts which are focused on cases, developments and issues impacting international commercial and investment arbitration. My name is Ian Meredith and I'm an international arbitration partner based in the London office of K&L Gates. Today I'm joined by Stephen Minas, Professor of Law and Director of Sustainability, Innovation and Law Circle at the Peking University School of Transnational Law for a discussion of aspects of state-to-state or interstate arbitration. Stephen is an expert in public international law and dispute settlement and has worked with a variety of international organizations in the area of energy and climate change. He's currently Vice Chair of the UN Climate Technology Centre and Network Advisory Board and a member of the UN Climate Technology Executive Committee. Stephen participates in the EU legal team in UN climate negotiations. Before we get started, I have some very brief comments by way of introduction. This presentation is limited in scope as appropriate for a general audience and taking into account the time constraints. It's not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case. All speakers appear in their personal capacity, and any opinions or views offered are those of the speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP or any other entity or individual. Stephen, thank you for agreeing to speak with me today. Let's get right to the heart of this. What is interstate arbitration and how is it different from other forms of arbitration?
Well, first of all, Ian, thank you for the invitation. It's great to be here. Interstate arbitration is just that. It's arbitration between states, generally between member states of the United Nations. It's a way that states can settle disputes between them on the basis of law and have a final and binding outcome without going to an international court. So there are important differences between interstate arbitration and a process before the International Court of Justice or any of the other international courts. In that sense, it has certain resemblances to other forms of arbitration in the sense that parties can nominate members of the tribunal. Those members will then select the president of the tribunal and so forth. So they're not limited by the procedure or the membership of a standing international court, but it is a law-based process and it is a process that leads to a final and binding outcome, that is to say, of course, an award. Today, it is one of the forms of peaceful settlement of disputes between states that are included in the United Nations Charter, far from the only one, of course, but it has become a significant means by which states resolve disputes that may arise between them. Now, as to the differences between interstate arbitration and other forms of arbitration, there are quite significant differences. More practitioners will be familiar with commercial arbitration or indeed investor-state arbitration. And these are forms of arbitration which have a much greater volume of cases than interstate arbitration. With interstate arbitration, of course, the parties are states. They are not private corporations. They are not investors. They are not indeed international organizations or any of the other kinds of parties that we see in other forms of arbitration. That is to say, the parties to interstate arbitration will generally be submitting their disputes for resolution on the basis of public international law. So the body of laws is different to other forms of arbitration. They tend to be handled by different institutions. So the largest institution that handles interstate arbitrations is the Permanent Court of Arbitration, the PCA, which of course also handles other forms of arbitration. But when we look at the major international commercial arbitration centers, then that's a completely different area of practice. Also in terms of the outcomes, and if we look at interstate arbitration, there is no equivalent to the annulment procedure that exists in the case of ICSID. For example. So the idea that the interstate arbitration is final and binding is very significant. And just as I said, the fact that there are far fewer interstate arbitrations. So this is a much smaller area of practice. And just to put that in numbers, the PCA are currently running 6 interstate arbitrations. And then again, bearing in mind that this is the largest institution by caseload, that gives a sense, I think, of the limited size of this jurisdiction.
On what basis can one state take another to arbitration? What's the sort of underlying trigger for being able to do so?
Well, as with other forms of arbitration, the basis for jurisdiction in interstate arbitration is consent. So parties have to have consented to arbitration to resolve their dispute. Now, consent can arise in a number of different ways. There can be a consent given by the parties to a treaty, either a multilateral or a bilateral treaty, to submit certain disputes arising under that treaty to arbitration, and indeed to international courts or other forms of dispute settlement. Or parties may find themselves embroiled in a dispute and then come to a special agreement between themselves to submit that dispute to arbitration after the dispute has arisen, which happens. It's, of course, very difficult, but it has happened. With interstate arbitration, there are very few multilateral treaties that provide a blanket requirement for states to submit disputes to arbitration. The great exception to that is the United Nations Convention on the Law of the Sea, which provides for several forms of dispute settlement, but has interstate arbitration as the default form. In other words, if parties have not chosen a particular international court, or the default form of dispute settlement is arbitration. And the result of that is that the great majority of parties to the UN Convention on the Law of the Sea are in fact governed by the requirement to submit their disputes under that convention to arbitration. And that's one of the reasons that if we look at the interstate arbitrations that have happened and which are currently on foot, many of them are under this jurisdiction of the United Nations Convention on the Law of the Sea, simply because it has a very strong basis of jurisdiction of arbitration in the text of the convention itself.
How can interstate arbitration contribute to resolving major international disputes? And I think here we're looking at the types of outcome that tribunals can give. What kind of relief ultimately can they or do they tend to award?
With interstate arbitration, there tend to be matters in dispute other than monetary sums. When we look at something like commercial arbitration or indeed investor-state arbitration, ultimately we're often talking about money one way or the other. When it comes to interstate arbitration, states are often concerned with matters of geopolitical significance, such as where their borders are as between the states in the dispute, whether those borders are on land or at sea. They are concerned with matters such as their rights to certain fishing provinces. They are concerned with the resolution of conflicts of various kinds, all of the kinds of disputes that can arise between states in the course of international relations. And because arbitration at the international level, and for more than 100 years now, has been primarily about the peaceful or the pacific settlement of the disputes, the outcome is generally not going to be most significant for monetary damages. The outcome will be the delimitation of a border or some other decision by way of award to regulate the future relations of the states concerned on a peaceful basis. And we have seen in the context of border disputes and their resolution, in the context of post-conflict scenarios between states which were at war and have found a peace but are in the process of working out the details of their peaceful relationships, that interstate arbitration has played an important role. And I should also say has played a role in disputes between states and certain non-state entities which were involved in some kind of violent conflict. So the outcomes tend to be quite different to those that we see even in investor-state arbitration.
So we're talking about things like claims to natural resources, say, for example, mineral assets that maybe on a question as to where the border lies and therefore who has rights to mineral rights, maybe things like water flows down significant rivers that pass through multiple countries, those sorts of things. Can they also be the subject of claims?
Absolutely. Everything that depends on where the border is legally drawn between two states is, of course, going to be and can potentially be the subject of these kinds of arbitrations. We also see matters related to the use of shared waterways, the construction of hydroelectrical facilities, for example, where those have a claimed effect on a downstream state or another state, submitted to interstate arbitration, and all kinds of disputes that ultimately have one state alleging that another state has breached its international responsibilities to it.
And in that category you've just touched upon, where you're not talking about coastal states, what tends to be the basis for the consent? Do the respective countries enter into an ad hoc agreement to take their dispute to arbitration, or is there some other underlying basis for that consent?
The majority of cases are brought on the basis of consent in an existing treaty between the states, either a multilateral or a bilateral treaty. So it's perhaps unsurprising that a dispute, a real-world dispute, arises between states, and the aggrieved state will then look for a legal basis on which to claim some kind of legal relief from a court or a tribunal, and more often than not, that will be found in an existing legal agreement between those states. It's again perhaps unsurprising that states who are going to be the respondent to a dispute will be reluctant to enter into a special agreement because they have no desire often to engage in defending their conduct before an international court or tribunal. But of course, where there is an existing jurisdiction under an existing legal instrument, it is harder, although as we've seen, not impossible, to avoid participation in an international legal process.
Thank you very much, Stephen. I think what we will do is address the more specific forms of dispute in a second episode. So thank you very much for your time today.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.